So Yvonne asked me to organize that. So let's start with that. Yvonne, why are we using janitors' props today?
Yeah, I'm training, I think, because I think I need to look for a new job now, because copyright is dead.
You are too early. You think copyright is dead, and I will prove you wrong. And we will be starting, obviously, with a charted case that you've already heard about. So let's dive in, because we have different opinions as we are lawyers. We always have opposing points on that. So what's your take on that?
Yeah, as I already said, copyright is dead. If you can start by just rewriting all software you want to and have no legal problems afterwards, then where's the problem still, and where do you need the lawyers anymore?
All right, not so fast. I mean, I assume everyone knows the charted case, at least since 30 minutes ago. And this feels wrong, and it is. Because just rebuilding software with AI and printing a new license on it, be it MIT or BSD 0, does not void the original copyright, I would say. Because even though the original was LGPL and the new code appears to be different, we have no new work. And according to Section 23 of the German Copyright Act, a modification of a work can only be legal if a new work is created. It says so in the language, a new work, neues Werk, has to be created. And a new work can only be created by human, because only the personal creation can result in a work that is protected by copyright. And if it's not copyright protected, if it's not a work, then the modification made that way cannot be a legal modification of the original work. And that's why LGPL will remain.
Yeah, but that might be valid for kind of texts you write or images you generate, but didn't you forget that we are talking about code here, software code, and that's a complete different section within the copyright law we have, or Copyright Act, based on the Computer Programs Directive, and there is no such thing as 23.
No, you sound like a lawyer now, but I will prove you wrong. I have 3 points that will just shatter your career plans. The first point was language, saying work has to be created by human. Now you're saying language in 2069B and C of the copyright code may be different and may refer to different architecture, structure, sequence, organization. But we have to look at why have we been looking at structure, sequence, organization. We've been looking at architecture because that was a proxy for human creation. We've been looking at software and saying, well, if the structure and the organization has changed, then that is probably because a human has put input into it. It's not a mere translation to a different programming language. The reason why we say we focus on the differences between the 2 outputs is because we are looking for human originality. And you may be right that the computer directive from the year 2009 or something like that may have been looking at that because the basis of that was the technology at that time, and that has changed. Today, we know that a different architecture can not only be created by human, but also by AI. And that means looking at different architecture does not mean you are looking at the original new work. So that means, Yvonne, it doesn't matter what the law said in 2009. We have to look at what is the human input, the creation of a new work, if you want to have a new copyright, or if you want to void the original copyright.
Yeah, but you're stretching the law quite a bit at that point now. If it is in the law, written in the law, you can't just come by and ask about creativeness with new arguments you're just thinking of.
Yeah, I know, you're conservative. You look at the language only. That's what young lawyers usually do. But judges are different. And senior lawyers as well. Yeah, you might be right. It's contra legem. It's not exactly what's written in the code. But when you look at the recent verdicts on AI, especially the ones from Munich, right here, if you look at the GEMA versus OpenAI, you will see that they are willing to question everything in Germany. They are willing to save copyright from AI. And that's why we believe, I mean, we are lawyers. We don't know what's really law. We just give predictions on what will come out in court. And at this present time, we have to prepare our clients that courts may rule differently in the future. Differently in the future because the basis of our assumptions have been in the year 2009 that human creativity is seen in architecture. And if that changes, that means the basis for that will also change. You cannot just rewrite code with Claude Code. That will not work.
So my job is depending on that we switch to some kind of case law.
Well, we know now. Well, sort of, yeah, sort of. I mean, maybe not in the first instances. We see that probably we will be looking at verdicts that are controversial, that are contradicting, and we will see different results in different countries. And that's the time when the lawmakers will step in. The lawmakers will be the ones who definitely save the copyright, not because they want it, but because they want to have security, harmonization. European lawmakers always step in when they see different countries, different courts coming to different outcomes, saying, we have to make a rule on that, and I'm sure they will save copyright.
Okay, so then I have to trust on the future, and how quick will that be?
Well, no problem. We will start we will first of all have that contradiction, and then we start a discussion, and then we have different interests, because that will be interesting. There are the ones who like copyrights and the ones who don't. They're the ones who make money with AI and the ones who make money with copyright. And the ones who used to make money with copyrights, well, they shifted sort of, or making money with services and AI. So maybe we will not count on them, but I'm not sure. I guess we all love copyright, so we will tell our lawmakers to make sure that the law will adapt to the new challenges. But I'm not sure. Give it another 5 or 10 years and we will have a good discussion on that.
Sounds really great. But I still think that's way too easy. It's way too easy to just put in the code and tell the AI, rewrite it for me. Keep all APIs intact, what stuff else, and then have a new result when nobody will find out that it's has something in common with the original product, because there's only less than 1% of similarity inside, so I'm fine.
Well, maybe that's why Chartered is not a good example for that, because the people doing Chartered 7 actually tried to not infringe copyrights. They are copyright peoples after all. So what they did is spend a lot of time making almost a clean room implementation and telling Claude Code, as if it would be really listening to its own prompts, to not read the original software, even though it's implemented in the training material, but at least they tried to come out with something that's completely different and novel. However, if you do the same thing by just saying, rewrite Microsoft Office or rewrite the Linux kernel, probably you will find more artifacts than these people did. You will probably find strange things like we had with the magic number algorithm, where even the comments were copied verbatim from the training material to the output. Do we have that here?
Yes, we brought it.
Yeah, everyone knows, what was that game, Quake 3D? Who are the old people who still played Quake 3D on a... I said I played it on a 386. That was corrected. It requires a coprocessor. It has to be a 486 DX4100. I had one of those. Who else is that?
First on those conferences where a lot of technical people...
Yeah. So no one played Quake, but you have to calculate a square root, and there's an algorithm for that, and that's described. And we have the same code on the left and on the right side. We even have the same very educational comments, what the fuck, because that's the magic number. So that's in both instances. And we have a license. What do we have as a license here?
BSD2 clause?
Very good. That's the original license probably, and we can do with that whatever we want.
Unfortunately not. Unfortunately, this side is the original license.
Oh, wow, that's painful.
Sorry.
So what's that?
That's a GPL, I think, yes. So it has copyleft.
Okay, but the other one is much better.
Yeah, and that's the AI-generated code. So you want to go for that one?
Well, what that shows us is probably in the future we cannot trust the heading information. We cannot trust what copyright is stated there. We will have to go deeper into it. And probably they will not make it so easy for us to just verbatim extract chunks of code that you could find with Black Duck or Palamida for Flexera. Probably if an AI agent would be more sophisticated, it would come up with a similar architecture, a similar algorithm, but have different variable names. So that is going to be one of the changes. That's actually one of the reasons why you will not be needing this one except for your own home. And that's practical, you know. I even brought my drink in that. So that means FOSS compliance is not getting obsolete, it's getting more complicated because you will not be just looking at FOSSology reports, but we have to look at what the code actually is. And you will need AI for that.
Yeah, so it would have been quite an easy way to recommend to just rewrite every code inside and then have no need to do any FOSS compliance anymore. But that might not be so easy, so that's not the right.
And that's my third point, actually, that whenever you use AI, you will not have a clean room implementation. Clean room implementation would mean that you have a team that has no view on the original source code. You don't have that. Claude Code has seen everything, or Copilot. They have been trained with everything that's published on GitHub. So you cannot just tell them, don't look at GitHub. He will say, yes, sure, I never looked at GitHub. And what he actually understands is, you don't want me to look like I looked at GitHub, but everything I know comes from GitHub. So there's no point in doing it. When I asked GitHub Copilot, Claude Code to rewrite Charlotte, it cost me a bunch of tokens, and 3 hours later he said, here's the result. I have no idea how I did it, obviously. So now, don't worry, we will be in business for a while with FOSS compliance. And actually, what our task as lawyers today is to make sure for the uncertainty that's coming, because frankly, we don't know what the legal situation is. We are lawyers, we don't know what's going to come, but the contracts and the projects that we do today have to be fit for the legislation of the future, unless your products will only live for 6 months. But if you're doing durable goods and you're purchasing software, you have to make sure that AI is considered in that. The first thing about that is you have to make a decision if you want your suppliers to be allowed to use AI-coded software, because as we learned just a minute ago, the software that comes out of AI may or may not be infringing other copyrights, but it does not have its own copyright. And that's a problem. If you were obliged to transfer rights, if there are no rights because you didn't acquire any, you are in defect of your contract because you did not provide any rights to your customer, to the OEM, or to the end customer, because you promised them to have proper usage rights or protection rights, IP protection, which they actually don't have.
Yeah, so that's a big risk. I think we can switch now to our legal case.
Actually,
so is that?
Yeah,
I have a question.
Oh, jump in.
Asking. So let's assume I'm a software supplier and I'm subcontracted by an OEM in the automotive industry. Let's assume I generate my code with AI. So my understanding is I do not own copyright. So I can't, according to standard contracts, transfer these rights to my customer. Could my customer literally take that code and say, hey, we don't pay you because you don't own it?
Yes. Not only not pay you, but actually make you pay your client to recreate humanly code that is properly protected. Because by contract, if you have a classic contract, it says you provide exclusive usage rights to your customer, and you don't. You didn't. So you are in defect of your contract, and actually you spend a few nights to clean up and provide better code, or your customer could do that and charge the cost to you.
That may be saying, if you may come to that point, just stop me anytime. We talk about copyrights, and one of the interesting things with current open source licenses is usually, at least for that concrete implementation, which is done in open source, the contributors at least need to auto contribute their patent rights into the implementation. There may be still third-party patent right infringements because certain other companies who are not involved in the open source generation, still may own patent rights. If I now regenerate the code with AI, I would not participate from this patent right grants, which are usually part of the open source licenses. That means I would be also literally then subject to patent right claims by even companies who granted their patent rights for the original open source work.
Oh, that is around so many corners. Well, so I guess everyone followed completely. Yeah, did you? I mean, first of all, patents does not depend on patterns, on expressions. So you can easily infringe patents even with AI code. There's no protection against that. So that's the first thing. And the next thing is the deal in open source licenses is I give you a patent grant in return of a copyright. There's always some sort of transaction. And that transaction bridge is somehow, well, in defect because there's no copyright or people don't participate in the open source model. And definitely, yeah, that's true. It could be that you are fortifying your patent protection if you do not use the patent grants in the open source license. Actually, Yvonne, we never thought about that.
We just thought about the competitors getting still another kind of law to start suing the people, because if you do not come from the Copyright Act, but still wanting to protect your own software idea. So maybe you could try also starting to use the law of prohibited competition, for example.
Yes.
So there are still quite a few other methods to get some kind of protection, even if you try to get out it by, for example, rewriting code or just don't caring about FOSS code being implemented in the AI-generated code.
That's actually my number 5 point out of the 3 points I was going to make. That was supposed to be the gag to come up with 5 points because everyone can just remember 3. And the last one's competitive law. But coming to the solution, if you are the supplier, which many of us may be, it's basically a race. Who has the better contracts first? Because what I would recommend you in that obvious situation is not to sign that contract, but rather tell your OEM, dear OEM, I will be using AI code. And you know what that means. I have no idea whose rights I will be infringing, and I have no idea if I can give you any kind of copyright. I can tell you that I will not sue you for copyright. That's all I can give you. If you don't want that, we go back to classic software production and classic prices for that. That's probably what you would do, and ask the OEM or your customer if he rather wants to go AI or not. Actually, that's the same thing we do with our customers, with our clients. We ask them, do you want us to use AI and be faster and maybe more or less precise? We don't know. Or do you want us to pay by the hour the classic way? And surprisingly, most people actually want us to use decent AI if we take responsibility for the outcome in the end. So that could be a fair deal, but the question is, how does the culture about these contracts develop? Because you will probably encounter lawyers on the client side who say, no, we want the same language we've had for the past years, and I don't care about the prices, because prices are not negotiated with lawyers. They are negotiated with the procurement department.
What I saw is procurement then issue a new thing was saying, no, you need to drop because, yeah, it's fine, you use AI. And then the lawyer are saying the opposite. So
yes, that's exactly what is happening, because the procurement and the legal teams don't understand yet, unless they are here. They don't understand that that the basis for developing software have changed, and the copyright concept that we used to have do not work. Well, they work fine maybe for the OEM, because when I talk to OEMs, I would say just make sure you prohibit any use of AI, so they are in defect to start with. If they do, they have to take full responsibility that they checked every line of code, every algorithm, and made sure and guaranteed that they are not infringing and they are yet providing copyrighted protection for us.
And obviously that might mean exchanging one compliance system against another. So you have an established FOSS compliance system, for example, you can already use, and now you need to change it for implementing AI-generated code for all these checks that might be necessary to make sure that you do not infringe by the AI-generated code, and you switch your one compliance process against the other. That might be more complicated still.
So and that was actually, yeah, sure, go ahead.
Is it by default that AI-generated code cannot be copyrighted, or maybe there in the future that you have maybe a business license from cloud that for your specific, you pay maybe much more than currently, but then you are allowed to copyright it, what is generated from the AI?
Everything is possible. My point from the original here was the AI-generated code is copyrighted, but not by the one who generated it, but by the person who wrote the original training material. And if you go with OpenAI versus GEMA, the other way around, that would mean that the output is actually copyrighted by the original author of the training material. So we will be needing license contracts for training material for OpenAI. And that's probably why we will be making our money in the future, by just getting license fees for the output that's created and maybe not further license. I don't know what the future will bring, but we know we have to keep producing software and licensing it and creating contracts for that. And that's the exciting situation that we are in today.
Sorry, go ahead.
As a human, if I create all my agent, my skill, and etc., so I do some creativity. So I influence the AI, so it's not obvious. So I use AI as a tool to produce something, but I'm creating something. So.
Very important point, because we were making it too easy here, saying it creates software and has no copyright. Because when you use AI as a tool and have a lot of human input into it, it is possible that the human creativity, even though you are using a tool, still renders a copyright, still renders a actual individual work. And our recommendation there is to document every decision, every input, every prompt that you made, everything you wrote by hand. In the chartered case, we have that documentation, and it's actually excellent. We know what they did, what he did. We don't know if it will be sufficient, but at least we have a documentation of what he did, and that's what we are recommending software developers
We
do.
also have already discussed it with development teams who think about giving commit logs with the output of the AI, so that they document their AI use within the commit logs of their development.
Use a tool
system.
for that.
So just,
You have the slave there.
Just to be sure.
You generate the agent with AI anyway, but it's your agent, because you say, no, I want it like that, I want this, and something documentation is, but you want the documentation. And by default, AI will not do it, so therefore there is an influence of human.
That's what you have to start when you're prompting in the beginning.
Is that a very specific German discussion we have right now? This a European discussion, or do they see that discussion happening all over the world? Because one of the things, if we again in Europe target from a compliance perspective, the rest of the world just don't care.
Well,
I think that's something which would maybe not help us to be closing some sort of technology gap. So while I think that's a valuable discussion, if others just don't care, and maybe Europe is still a big market for most of the companies, but if we just depend on the market side as the customers, it's maybe not valuable enough or not impactful enough to have.
It's really difficult because we don't know what the future legislation in Germany and other countries will be. There are different similar cases, especially in the US, with a different legal system, of course, with fair use coming to different outcomes. But when we look at 20 years ago about open source compliance legislation, there's a reason why all that legislation happened in Germany, partly in France. It was German courts where they tried those things. Interestingly, it was the same court, Munich #1, that the GEMA chose for the case against OpenAI. Also, it was the same court that we chose for the case against SAIC, the producer of the MG4 car that has no
good switch.
copyrighted material, and that's actually where the second part we wanted to talk about. That's my car, and this car is completely illegal as for its software because it has no compulsory statements, and I've been waiting for source codes for the Linux kernels, many of them inside there, for almost a year now. Well, actually more than a year. So what the producer, the seller did is they picked up the car, and of course this car cannot drive on a road because that way it would start its operating system, and it doesn't have a license for that. So they towed it to Nuremberg and returned it 2 days later with a QR code now in the main unit. It has a QR code that brings us to compulsory statements. That way at least we know what is supposed to be inside. That's interesting because formerly we didn't. And
now we have a listing containing very much GPL software.
Lena, do you remember more than a year ago I wrote you a cryptic message saying, I think I will start more awareness for open source.
Yeah.
And you said, what the heck is he going to do?
This is what we've been doing for the last 20 years.
That's what you said, but I chose a different approach. And that's one of the things that's happening here. I think we did change the market. I was at different conferences, and I get checks from Chinese lawyers now. No, I don't get checks. I just get business cards and say, because of that case, I have a lot of business here to do, and they have a lot of work to do. Because what we are learning here from this SAIC case is if you want to create compliance with an existing product, it will at least take you more than a year, and you will not have a result after 1 year, and probably you will not ever have a satisfying result because it is not done by just displaying compulsory statements. If the copyleft software is connected with other software, you will simply not be able to provide licenses for that. So it would be bad for the card, for the hardware, but that software cannot be legally operated. And the question that we will be answering in October. In Munich, the date is public somewhere, is the question, can a customer claim for the defect and get his money back? Or, I didn't want my money back. I don't care about money. I want the defect to be cured, which could be much more expensive for the vendor than just returning the money.
So maybe would that be an individual case? So if you would get your money back because you would complain if it's based, so if nobody else would do this, that would literally mean that the cars could still operate on the streets illegally, or that's something where then the government steps in, or what? Not government's most like the right authority. Is that something then which, like homologation or other things, any kind of approvals would be withdrawn if that would come true?
Well, obviously in Germany this is just an individual case between two persons, me and SAIC, or our company, the Jun Legal GmbH and SAIC.
But SAIC is not so happy that you provided for that case because, of course, as somebody is talking about that case all the time in social media, on the internet.
No, we wouldn't do that. Please don't mention this case. This should remain here. Yeah. Because what is happening is, remember all the people who did Dieselgate, who did all the lawsuits, 10,000, 20,000 customers suing the OEMs. They're the ones calling us, hey, how much longer do we have to wait? When is the verdict? Can we come? Can we understand? What's this open source you're talking about? Is it the same like exhaustion Schadensgrenzwerte? I don't know. They are waiting for that. So, but the good question is, would there be anything official happening, like Zulassung?
Some punishment by or the infringe law or something like that, or that something which is really between two civil parties?
Well, currently nobody is really fond of exaggerating, escalating that things to an official basis, but we don't know because this car has requirements in order to get a Zulassung, what's that in English? The permission to drive on roads, and we do see some risks there. So something could happen, but I think everyone is just waiting for that verdict.
If they will do something on their own, but by not being prompted by anybody, I don't think so.
Sorry for my stupid question, because I am all the time, which is quite unfair. So I think the rest will start with a lunch break, so feel free to add some information, but if
No,
we wrap up this next 3 to 5 minutes, that would be highly appreciated.
Now we can just leave that everything to the panel where we will be in the afternoon and just continue on to that discussion what it means for the future. So I assume we will see you there. Yvonne, what else did we want to say?
We're fine.
We're done
We're
with
fine,
that.
yeah.
So let's have lunch, and if you have questions, just come up to us. We will be around.
Perfect. So,
Thank you very much.
I think that was. Thanks for the presentation.
And we return it to the hotel.
The interesting thing is, how does the, maybe as a final question, how does the industry, so what you just presented is uncertainty. So you said it depends on future. So how do companies hate uncertainty?
We always love it.
Yeah. You're earning money with it. But the question is, what is the reaction of companies? Is it like more, we don't care, or we need to have at least some money in the bank just to deal with this kind of
that's
lawsuits?
easy.
Is it, let's go back to traditional open source. What is the reaction of companies?
Having the best contracts.
Okay.
That's a point to start. So
Yeah.
if you are the first to have a really good clause in your contract and the others don't have, so you at least have a starting point. Where we're the first.
Advantage.
Yes.
We learned about the Chinese strategy here because what they did is they knew there was something going on open source. I mean, they've been tended for by big law firms for the last 10 years. They came here and probably people asked them, how much effort do you want to invest into compliance? And they said, well, what happens if we don't do it? Well, for now, nothing. Well, then let's just reserve some money when it actually happens, and it happened. So what's going on in China now is everyone is very, very active, calling their suppliers and trying to find out what kind of software is in that car.
So welcome in the modern world of open source. So thank you so much.
Who's to blame?
All right.
Lunch outside, I assume